Everyone, Lee Pacchia here, and you're watching the Markman Minute, where we talk about everything at the intersection of intellectual property law and investing. I'm joined now, as always, by Gaston Kroub from his office in Lower Manhattan. Gaston, good to see you.
See you, Lee. How you been?
Not too bad, not too bad. So we did a lot of talking a couple weeks ago about the trial between Merck and Gilead. We have a verdict now. What's in the bag? Let us see.
All right. So, we have talked about this situation. Just to reorient everybody, this patent case deals with Merck's attempts to get royalties from Gilead on two of the biggest selling drugs of all time, hepatitis C treatments, called Sovaldi and Harvoni. The Merck had asserted two patents in the Northern District of California in San Jose, and the jury came back after a couple of days of deliberation and said that Merck's patents were valid. Meaning that Gilead was liable for infringement since that had been stipulated to before trial. Then the jury went back for the second part of their mandate, which was to come up with a damages number. And one of the reasons this case was very interesting, not only to patent lawyers and the pharmaceutical community, but to investors, was the potential exposure for Gilead. There was $21 billion worth of sales that were available as a pool for past damages. Merck was asking for 10% of that as a royalty. So that would be about $2.1 billion through trial. And then obviously on a going forward basis, with about five more years till those patents expire, if they could get a royalty rate of 10% on future sales, this had the potential to be one of the most valuable patent cases of all time. What ended up happening, though, is the jury went back and, knowing as they did that the patents were valid and infringed, they came up with a number that was, I think, surprising to a lot of people. Their number was $200 million. And the way they got to $200 million as opposed to $2 billion was by, first of all, completely writing off $15 billion of the sales as related to Gilead's investment. So what they said was, all right, Gilead, you spent $11 billion acquiring Pharmasset, which is the biotech company that had developed the molecule. And you had all these other costs. So really the royalty base should only be about $5 million as opposed to 21. And then what the jury did was apply a pretty severe haircut and say, look, Merck's not entitled to 10% of that. They're only entitled to 4%. And they came up with this $200 million number, which had to have been disappointing for Merck and Merck's investors, and also the company that Merck had licensed the patents from, a smaller biotech company, formerly known as ISIS, unfortunately now known as Ionis. And it was a sigh of relief for Gilead because having to write a check for $200 million when you're booking billions a month in revenue was a lot more palatable than having to write a $2 billion check. Now, what's left on the table, right? What's Gilead's continued exposure? Now, right after the jury came back with its verdict, Gilead had an opportunity to do a mini bench trial, meaning to the judge only, on their equitable defenses. And in particular, they focused on this unclean hands defense. And this is a really interesting story and very atypical for the patent world. But basically what happened, and this all came out at trial, was that when Pharmasset was developing this molecule, Merck was also in the process and looking at this. And this goes all the way back to the 2001, 2002 timeframe. And Merck was a potential buyer of Pharmasset. And as part of the due diligence in that proceeding, they had an agreement between the companies that Pharmasset would basically lift the kimono as to their development activities. But Merck had to kind of pledge that no one involved in patent prosecution or in acquiring patents for Merck was going to, have access to the really sensitive information. And obviously, the most sensitive information was what's the molecule that's actually working to cure hepatitis C? Like, what's that chemical structure? But what apparently Merck did was when they had certain meetings with Pharmasset, not only did they send someone involved in patent prosecution, they actually sent their head of patent prosecution. So their chief internal patent prosecutor went to the meetings and got the information about the molecule. And Gilead's argument is that he later took that information and used it to get the very same patents to write claims in the patents that Gilead is now being sued over. So they basically accuse Merck of, some form of corporate espionage, finding out this information, using it to their advantage, and then trying to, hold Gilead up based on it. Complicating matters for Merck, and this may have been a factor in the jury's verdict and discount, 90% discount. Merck's witness, this former patent prosecutor, apparently lied at his deposition. And he said, when I went to this meeting with Pharmasset, no one told me what molecule they were working on. No one gave me that information. And it turned out that there was someone else at the meeting that Gilead uncovered. They also uncovered contemporaneous notes from the meeting that proved that this guy was lying. And this all came out on the stand at trial. He had to kind of backtrack from his deposition testimony. So, you could only imagine that the jury may have felt, look, these patents are valid. We're not really in a position to say they aren't. But, Merck wasn't necessarily a white knight actor here. And that may account for the discount. Now, if the judge buys this unclean hands defense, she might throw out the verdict completely and render the patents unenforceable as against Gilead. So very interesting kind of, corporate espionage type story, which I don't know that a lot of people expected when they look at this from the outside and they see what looks to be a straightforward patent case.
No, fascinating stuff, and like you said, it's noteworthy in that this verdict just isn't as big as we thought it was going to be a couple of weeks ago, or feared it could be.
Right. Well, there still is the, what do investors still have to watch for, right? There's still the ability for the judge to completely make a hash of the whole trial in the post-trial motions. She might decide that the jury got it wrong on damages. She might decide that the jury got it wrong on liability. She may decide the unclean hands in Gilead's favor and throw out the verdict completely. So I think for now, everybody's got to wait and see, what does she do with the verdict? Does she import, any ongoing royalty liability for Gilead, which could add up to the billions, even on a 4% royalty. And really, at the end of that process, what you're going to have is a nice package that both sides are likely to appeal to the federal circuit, and we'll go through that process. So I think for now, Gilead's done a good job of avoiding that big headline verdict that really could have spooked investors. And, it looks like this story may play out over the next couple of years, but, for now, it's just hard to see how Merck really looks that good based on the fact pattern that came out of trial.
Good stuff. Gaston, thank you for your time today, sir.
My pleasure. Thanks, Lee.
That's Gaston Kroub from Markman Advisors. If you'd like to see more of the stuff we're working on, be sure to go check us out online. You can find us at mimesislaw.com under the IP Flow tab. We're also on Twitter, Facebook, and LinkedIn. If you're listening to us today on a podcast, do us a favor and write us a good review on iTunes. We love them. If you're watching us over YouTube, do us a favor and subscribe to our channel. There's more good stuff coming, I can promise you that. I'm Lee Pacchia. Thanks for watching or listening. See you next time. Andrew, can jurors be racist?
Yeah, legally juries can be racist for the most part. Well, the question isn't really so much about whether juries can be racist, but how are you allowed to discover? So, for instance, if somebody overheard a juror in the hallway saying something very racist, you could probably bring that witness in. The rule we're talking about is